Welcome back. I'm Vince Perryman, and you're watching Legalese. Joining us on our show is Bill Jones of the Jones Law Firm. Bill, before the break, we were talking about contempt and just all the different ways that it can arise. And then I think everyone's got a clear picture on generally the nasty contempt stuff comes from poorly drafted orders.
Yeah, I mean, one of the things that you said was, and I think it's a great observation and a great point, is we get into these problems where folks their mouths write checks that they can't cash, or the judge orders them to do things they can't do, and we as the attorneys need to assist our clients in drafting these orders properly. I mean, in the heat of battle, in the heat of litigation, everyone knows the issues. Everyone knows who won or what the issues were. But to a judge, to a court, here recently we've had several judges that have had to take time off, or that we have new judges coming in. Well, when that happens, the courts, the judge sitting on that bench, he's not going to remember that you said this or you did that. All they have is that record. All they have is that final order. So despite the time that we spend on preparing for trial or preparing for depositions, really that final order that we enter with the court, drafting that is probably the most important thing your attorney can do for you, and it really needs to be something that your attorney spends some time on. The process there is once we draft the order, we send it over to opposing counsel. We have them look at it. They can suggest changes. If we can agree upon it, we do it that way. If we come to an agreement, we both sign it. If not, then both attorneys prepare their own orders, submit them to the court, and the judge chooses what they would like, or they outline what changes they want. But after that, the parties need to clearly understand what the order says, because that's their rule book. That's what, when they come back in and want to complain, whether it's justified or not, that's what they're going to be held to.
Right, and that's, it brings up an interesting point in my mind when we talk about new judges on the bench and things like this. As we go through, especially with family law stuff, where if we're dealing with a child of a tender age, if you will, under 2, we know you're probably going to, if this continues to be contentious, one, it's not good for the child.
Sure.
Then the other thing with it is you're going to have a long record here in the history of this. And it's one of those where sometimes if someone is in contempt early on and they continue that action, or you think they're going to continue that action, I always advise we're probably not going to be win on this contempt action, but we want to put it in there so that way we've got it in the record, so there's a history of this. So should we go up to the Court of Appeals, the Court of Appeals sees, oh, okay, on X date, parent A took the child away and took away 54% of parent B's parenting time.
Well, that brings up the question of when do you file a petition for contempt? And I tell my clients, it's a lot like being married. You've got to learn when to pick your battles. Every offense does not merit going in, hiring an attorney, filing a petition, and going in front of the court. Especially in a family law setting, that is one area where you do not want the judges to become familiar enough with you that he sees you coming in and says, hey, I know these people. You want to pick your battles. What your documents are going to say is that your failure to enforce does not waive your right to go after and enforce it later. So you can let some of the small things slip and actually get a laundry list of things piled up, allow enough time to go by, and that's when you can go by. But I tell folks the first time you file a petition for contempt, generally a slap on the wrist is what you're going to see.
And I think too, the other thing with that is the part of that course of, if you are thinking that this is rising to the level of contempt or something, and you're being given notice prior to the contemptuous action occurring, such as, say, you got parenting time on a certain day and a certain time, and your ex-spouse calls you up and says, look, I'm going out of town, so you're not going to get that parenting time. You know, would you be amenable to changing that? Then what the court wants to see is somebody to have the ability to co-parent there and say, well, yeah, let's work this out. And as long as you're being reasonable, then I think, and you can work that out, that's good. You want to keep a record of that. But if you've got a situation where you're being reasonable and the response is I'm not going to compromise with you. This is what I said I'm going to do, and I know it's in violation of the court order, but I'm going to do it anyway.
Yeah.
Then you may be left with no choices. And that's just one of those examples of, you know, and when the kids are in the middle of all this, it's quite a mess.
You know, you see topics that come and rise and go, and one of the topics that we're really seeing right now in the law and in our contempt petitions is failing to facilitate and encourage a loving relationship with the other parent. And in plain English, what that means is, don't talk bad about your child's other parent in front of that child. I mean,
right, and don't let your relatives or friends do that for you either.
Absolutely.
You know,
that's not your place.
Right.
Let that child. You just parent that child, and when that child's old enough, they'll figure it out.
Right, and part of what I say about the facilitation, it's also making sure that the child is there for their visitation with the other parent. It's not dropping the child off and saying, oh, look, here's mommy, and there's mommy, don't you want, you know, it's not that. It's making sure that you're fostering that relationship so that kid has what they need, which is both parents.
Well, you know, it's even the little things that we say. I tell my clients, if you're waiting to do an exchange and one parent's late, it's not, oh, your mom's late again, or oh, your dad's late again. That's negative. It needs to be, oh, they'll be right here.
Which, speaking of time, we're getting the wrap-up signal. So we'll talk more about that when we come back from the break. We'll talk more with Bill about legal contempt when we come back. Stay with us.